Our next speaker is Kate Stimeling, the litigation partner at Schiff Hardin in San Francisco, who focuses her practice on product liability and employment matters. Kate brings an added dimension to her trial practice with her experience in developing financial projections, annual budgeting, and forecasting. Kate finds that developing trial themes early in a case helps to direct and focus discovery and experts in supporting those themes. Here to discuss how, when, and why to use surveillance materials in discovery is Kate Stimeling.
Good morning. Let's get started. I'm going to jump into the use and purpose of surveillance materials in litigation and discovery, and let's get started. The first topic is the purpose of discovery. Why would a trial attorney litigator recommend to her client that she undertake the expense of surveillance? Let's face it, surveillance isn't cheap. It can take hours, it can take days, and before we recommend to a client what types of cases are appropriate for surveillance. This could cost a couple of $1,000s, could cost more. It may not ultimately be a huge expense in relation to the risk, but let's make sure we're doing it in the right case. The most common and obvious type of case where we use surveillance, and surveillance is helpful, is the contested personal injury case. You're going to have a fight on damages. You're going to have a fight on the effect of the medical injury to the plaintiff. Another area where surveillance is helpful and ripe is in the employment situation. You've got a former employee or a current employee claiming that he or she can never work again because of some act of harassment or discrimination. It's good to get that person out enjoying their life. I have found that surveillance is particularly helpful in cases where liability is not going to be contested, where you're dead in the water on liability. Those types of cases, plaintiffs and their lawyers seem to get dug in, they get stuck in on general damages, and it's nice to have surveillance to sort of bring them back into reality in terms of the value of their case. So what are we going to do? We're going to try to attack the credibility of a plaintiff in a personal injury or an employment case. We want to try to expose the plaintiff as a fraud. Can you box the plaintiff in with his or her testimony in a way that shows that what they're trying to say on the stand is completely at odds with what's caught on the video? If you can't expose the plaintiff as a fraud, can you show that he or she is an exaggerator, someone who's overstating the extent of their injuries or their damages, and very often post-traumatic stress as a result of the incident? By attacking the credibility of the plaintiff, we hope to drive down the value of the case. In a perfect scenario, which you'll see in a moment, you can get a case disposed of altogether. In terms of purpose for purposes at trial of using surveillance, juries easily understand video, they easily understand photographs, so if you can put something up, keep their attention and keep them focused, they'll understand it easier. You don't have to say much if there's a video capturing the plaintiff doing something he or she said they couldn't do. And finally, it's entertaining. So with that, we want to turn to our first case study. This is a plaintiff who fell in the workplace. He did, in fact, fall in the workplace in 2008. He testified at his deposition that he could not drive, that he could not dress himself because he had no use of his arms, he could not stand up, and he needed a cane or a wheelchair to get around at all times. So here we have him. This is the afternoon of his independent medical exam. I made the strategic decision to have a private investigator capturing footage of him at the IME. We had a second private investigator at his home, and you'll see that in a little bit. Here he is with his sister who is in on it. He's using the wheelchair as he testified to. This is consistent with his deposition testimony that he couldn't walk. He could barely walk with the use of a cane, but he really, really needed a wheelchair. He needed the assistance of his sister, and here she is delivering him from the IME back to his vehicle to get him home the day of his independent medical exam. Earlier in that day, we caught him driving his vehicle. There he is, using his arms, which he said were inoperable. He's driving, and there he is rolling up his window, and he is reaching into the back, you'll see, to grab that cane that he needs because he can't get around without it. Now, this is the day of the IME where we saw him in, and here he is getting out of his car. He thinks he should probably use his cane, and that is too much of a difficulty for him. So we capture him. So this is, again, like I said, I had the private investigator at his house. Again, you'll see him here. They actually spot my private investigator. She's pointing to him saying, hey, check out the private investigator. He's having a tough time getting to his car. He's dragging that foot. He's just really having a tough time. His sister needs to drive him, of course, because he can't drive. And this was before we got him at the IME where he needed the wheelchair. The wheelchair is in the back. It's in the trunk. But he forgets later in the day, and he's pretty good getting home. Needless to say, that case went away. He was confronted at his deposition. He lost his lawyer, and he didn't show up at trial. A very interesting issue, though. What's the discovery? What's the rule on turning this stuff over? Let's assume you get some great surveillance. What are the rules about, number one, disclosing the existence of the materials, and then number two, turning it over to the other side? This has been a long-standing dispute between the plaintiffs and defense bars for obvious reasons. The defense bar has always said, look, this is impeachment. If I tell you I have it, if I show you what it is before trial, the plaintiff is going to be prepped, and they're going to be able at trial to change their tune and work their way around it. On the other hand, the plaintiff's bar has always said that it's just patently unfair. There's just way too much prejudice for a plaintiff to see this stuff for the first time at trial, and I, as a plaintiff, I have rights too, and I should be able to poke holes at the surveillance and possibly come up with counter evidence to explain that particular surveillance. As with most issues of discovery, if you're in a state court action, definitely get to the jurisdiction and the state where you're located. Here in the great state of California, surprisingly, shockingly, this has not been expressly addressed. Although in 1962, with film footage, as they called it, it was new and novel at the time, the Cal Supreme Court suggested that it could be discoverable. Ultimately, the determination of whether surveillance materials is discoverable is going to center on the analysis the courts have gone through of the work product doctrine and whether the work product doctrine protects the materials from disclosure. And those discussions in the cases focus on three areas. Is the defendant going to use it at trial? Could it result in injustice to the plaintiff? And is the video to be characterized as something interpretive from the trial attorney, or is it more in fact akin to evidentiary evidence, evidentiary materials? And the courts generally find that it's similar to more evidentiary than interpretive. And what we find is that courts have balanced these competing interests of the plaintiff wanting to avoid prejudice and the defendant wanting to be able to impeach the plaintiff by ordering that in most situations the surveillance is going to have to be turned over. It's not protected by the work product so long as there's a chance to depose the plaintiff and use it and catch the plaintiff in a pseudo-impeachment situation at their deposition. So this has been addressed by several courts. The general rule in federal court is that there's no work product protection for surveillance if it's going to be used at trial. Because the plaintiff has a substantial need to avoid that prejudice, and he or she is unable to attack the evidence itself. This has been addressed in Missouri, New York. We've seen it in Iowa and New Jersey. Interesting, in New Jersey, the court held that the camera itself can be an instrument of deception, and I think that was back in 1976. That is certainly probably more true today. So you've got the goods, you know you need to give them up. What are you going to do, and what's the best practice in terms of the procedure? What we do procedurally is going to be informed by the general rule that this stuff generally is not going to be protected under the work product. So get the goods, go through that analysis. Is this the type of case where you want to get the surveillance? If it is, one thing to remember here, and this is under the respond, object to the request to produce. And I'll talk about this in a little bit. But at the time that you get a request to produce surveillance materials, you may not, in fact, actually have the surveillance materials. Don't forget to do your written objection on work product, even though ultimately it may not stand, but there could be reasons to do that and make your objection. Hopefully do the surveillance before the deposition so that you know that you know the surveillance materials well enough so that you can take a well-informed deposition. Know what type of activities are shown in the video so that you can try to trap the plaintiff and get the plaintiff stuck in on his or her testimony. Make the determination as to whether you're going to use it at trial and produce it to the plaintiff. One thing here, a cautionary note, be prepared. If you have hours and hours of video surveillance and you think you have one gem, you have one diamond in the rough, be careful. does the balance of your surveillance actually prove the plaintiff's case? What you don't want to do is to go for it in terms of that one nugget and be faced with a court telling you, well, you don't get to just talk about the 5 minutes or the 5 seconds. You got to go back and you got to turn over the plaintiff weeks worth of surveillance or hours worth of surveillance. Is it worth it? Again, we see this following through, this has become the general rule in federal court, and we're seeing it in California trial courts. And I've already covered that. Make sure that you serve your written objection. And some courts have said a plaintiff will have to move to compel to get it. When should the defendant, should you be using the surveillance? If it's good enough, as in the first scenario, you might want to do it early in the case. You may want to use it at the deposition to let the plaintiff know you have it. I have found that at mediation that can be incredibly successful if you have a very good mediator who can use good surveillance to leverage the plaintiff back into reality in terms of the value of the case. If you can't do it in one of those situations, but you know you want to use it at trial, produce it just before trial. As I said, the trickier issue is if you get a request for this surveillance and it doesn't yet exist, and the plaintiff doesn't follow up with a supplemental request. Err on the side of caution, produce it if you know you're going to use it at trial. Case study number 2. And I'll talk you through this, but this involved a massive explosion on a freeway, a collision between a chemical and a gas tanker, and the plaintiff was the driver of the gas tanker. He claimed serious neck and back injuries, but more importantly, he just claimed general post-traumatic stress. I mean, he just talked endlessly about how awful his life was. He was prepared well for his deposition. He testified that he had good days and he had bad days. And that's the one thing that usually happens in these cases, which is why surveillance is important, not to attack a particular line of testimony or a particular statement. It's not always going to be the killer impeachment. It's going to be to attack the general gestalt of what the plaintiff has said. Now, here he is. He's out. We caught him on video doing yard work. He does a lot of gardening. He's able to get around. We have a lot of footage of him just going about his day-to-day life. He does a bunch of home maintenance, he pulls weeds, and again, he did testify that he had a range of motion problems, so this was helpful. He did have some surgery, but he just generally testified that he was a sad guy who didn't really want to leave his house because of this accident, and that's why his general damages were so high. We got a lot of footage of him just living his life. He was out and about. He was running his errands. He was riding his bike a lot. He was interacting with people. So the use of this video surveillance, like I said, didn't go to one particular thing, such as in the first clip where he said, "I can never drive," and we caught him on video driving. Surveillance is helpful in cases where a plaintiff just wants to say, I'm not the same guy that I was before the accident. I'm just unhappy. I can't leave the house. I'm so traumatized by what happened. I just really don't know what to do with myself. And there's just a bunch of additional footage of him on his bicycle, so I can move on. The initial demand in this case, because of the nature of the explosion, it was pretty captivating, was $5 million. In this situation, we used the video surveillance at the mediation. We didn't show it to the plaintiff, but we showed it to the mediator and used the mediator as our conduit to explain to the plaintiff why the case was not worth $5 million. The mediator did his job, the demand dropped to $300,000, and the case ultimately settled for $100,000. We did an extra zero on that. Case study number 3, again, goes to this issue of when you don't have a particular line item of testimony that could be characterized as pure impeachment. This is a case, again, going to the point earlier I made, I find video surveillance helpful in cases where liability is clear. We rear-ended this gentleman here on I-5 just north. It was up in Orange County. We knew we were going to be fighting tremendously on damages. He was sort of the picture-perfect Southern California guy. His full-time job was youth pastor and soccer coach. He surfed, he played soccer, he had major back surgery, and he just testified continuously that his life would never be the same again. His big point of contention and his claim against us, again, leveraging us because he had us dead on the water in terms of liability, we rear-ended the heck out of him. And in fact, he was on his Bluetooth with his wife at the time of the accident, and he said, "Oh my gosh, I'm about to get rear-ended by an 18-wheeler." So that wasn't helpful. He said he could never play soccer or engage with the youth again. Here's what we caught him doing. We caught him doing both. So here he is giving a private soccer instruction to a youth, and he spent a lot of time. We got a lot of footage of soccer, which was fantastic for us. But he was smart and he was well coached, and he testified, I have good days. Here he is he's in the white shirt. And this is a guy who's had neck and back surgery. So he testified, I have good days and I have bad days, which as a trial lawyer, you always know that this all happened on the good day. So it's particularly challenging. And what we did at mediation with this is and I'll talk about this in the next slide, but we got a lot of footage of him out on the soccer field. You know, the stress and the trauma of the accident really, I think, comes through in the video that we were able to get to show that it wasn't as bad as he wanted to make it out to be. Lots of video like that. So what happened with this case? Again, we use this video not to attack a particular piece of testimony or a particular statement that he made, but to attack his general credibility in terms of how awful and devastating this accident was to his life. What we did, though, and the decision I made at the mediation, was that I wasn't going to do it until late in the game and if he refused to get off his 7-figure demand. We had a very effective mediator who, for up until 6 p.m., kind of looked me and the client and said, you're dead in this, you're dead on this, you're dead on this. I got a guy in there who's a picture-perfect pastor, and you're never going to get around that. So we waited and we let him build up his story as we knew he would with a jury. We let him talk the mediator through his youth pastoral role and changing the lives of youth and be playing soccer. Showed the video at 6 o'clock and the mediator's first response was, oh shit. And by 9 p.m. we were able to get them down to a reasonable number in the low 6 figures, essentially covering the cost of medicals with a little bit extra for some general damages. And that was a good success as a result of effective use of surveillance. All right, just some guidelines, and these are printed out in the written materials, and best practices to keep in mind. Again, what type of case? If you're going to spend thousands of dollars on surveillance, is it the right type of case? Are damages going to be highly contested? Are you dead on the water in terms of liability? The rule of thumb in terms of discoverability, there are no more Perry Mason moments. If you get it and you want to use it, assume that you're going to have to disclose all of it. So again, if you get a mountain of it and there's only one little thing lying in there that you think you're going to want to use, be mindful of that. Does what else you have behind the curtain outweigh that golden moment? Get into your states and review your rules of evidence to see, but generally the rule at this point is it's not going to be protected by the qualified work product doctrine. Obtain the surveillance. Don't forget to object in writing. Obtain the surveillance. When you do that, make sure you get someone good. Get a licensed private investigator, because if and when you want to use it and the opposing side wants to dig into it, you want to be able to put someone into the seat who can answer those questions professionally and do it well. Don't forget, it's all potentially discoverable. In a perfect world, do the surveillance before the deposition. Know that surveillance inside and out, even if it means watching hours of boring surveillance, or have a paralegal help you out, have a service help you out with that. Find the nuggets, find the activities so that when you're asking questions, you can ask the right questions. Prepare for use at the mediation, and don't edit the video because your credibility is subject to attack at that point. Thank you very much, and good luck using surveillance, and I'm here to answer any questions after.